Hi, this is Patrick Conroy, and this is Chapter 5, Constitutional Law. Now, this is a big chapter. There's a lot of important information covered in it, but really, it could be its own course. We're really focusing on constitutional law as it relates to business, but there are some issues that affect you personally as well. Okay, so let's talk about the US Constitution. It established a federalist system of government. What that means is that there are really two main levels of government. There's the state government and the federal government, the one in DC. And they share power, and certain legal issues are handled by the federal government, some are handled by the state government. It also allocates power among the three federal branches of government: the legislative, Congress; executive, the president; and judicial, the federal courts. And it establishes a system of checks and balances. I'm sure you could learn this in high school, but we're just going to go over some of this real quickly. Okay, on the executive branch, what Congress can do as a check on the executive branch is it can refuse to approve a president's budget. And that budget covers all of the federal agencies, military, defense, all of that. And they usually do change it a lot during the process. The president can veto legislation he doesn't agree with, but the Congress can overrule the presidential veto if they have a 2/3 majority. They can refuse to approve presidential appointees. And this happens a lot these days. If Congress is held by one party and the executive branch is held by a different party, there's a lot of it that goes on. They can refuse to ratify treaties that the executive branch entered into. And they can impeach and remove president. The impeachment, there's sort of two parts. There's the actual impeachment, which means that they have voted to impeach the president by majority vote. The removal is a separate issue and requires 2/3 of the Senate. And that has never been done. We've had several impeachments, but no removal of president. On the judicial branch, they can pass amendments to overrule judicial rulings. There would be an amendment to the Constitution or an amendment to a law. They can impeach judges. They've had a little bit more success in removing judges, but it's not so much for their decisions, it's for things like gross incompetence or basically being a crook. Establishes lower courts and sets the number of judges. The country is divided up into many federal districts, and Congress is the one who sets those up and decides how many judges should be in each of the appeals courts. Okay. With the presidential powers for checks and balances on Congress, they can veto legislation passed by Congress. And they can call special sessions of Congress. If they really feel that the Congress has not done their job, they call special sessions. Then they bring them back to DC to focus on just one issue. The judicial branch, well, the president appoints the federal judges, and they can issue pardons on federal offenders. So if someone's in jail for a federal offense, they can pardon them. If they're in jail for a state offense, they cannot. The court system. On legislative branch, they can declare laws passed by Congress unconstitutional. And on the judicial branch, they can declare acts of the executive branch unconstitutional. So sometimes it's an executive order, they can find that unconstitutional. Law passed by Congress, they can find that unconstitutional. Okay, the Commerce Clause. Now this is it might have started out much smaller, but as interstate commerce has grown so much since 1770 or 1784, it has grown so much that it affects nearly everybody all the time. And what it says simply though is that US Congress has the power to regulate commerce with foreign nations and among the several states. And this among the several states has grown. I mean, it used to be people lived and died within 50 miles of where they were born. There was interstate commerce, but it wasn't like there were Walmarts everywhere. Most things were grown locally, consumed locally, built locally. Now that we have so much interstate commerce, this has expanded the reach of this part of the Constitution. And it empowers the federal government and restricts the power of state governments. Taxing and spending powers of the federal government. Basically, this is laid out, and it's Congress who has the duties and decisions about federal taxes. Power to lay and collect taxes, duties, imports, and excises. Taxes imposed by Congress must be uniform across the states. What that means is they can't say, hey, the federal income tax in Louisiana is 28%, but in Utah it's 23%. The federal government can use tax revenues to provide essential services, encourage development of certain industries, and discourage development of other industries. So this is big power. Now, even if it has a regulatory impact, it does not affect the Constitution. So even if the tax affects a business's ability to operate the way they want to, that does not make it unconstitutional. Okay, some other important constitutional restrictions in the government include citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. This is a big deal, and this is the 14th Amendment of the Constitution. So it was passed right after the Civil War. So before that, this didn't exist. But basically what it does is says that all of the powers in the Bill of Rights apply to the state governments as well. And we'll cover the Bill of Rights in a few moments. Yes, that's my cat. The full faith and credit clause means that each state must enforce a judgment by a court in another state, unless that original court lacked jurisdiction. So if you get sued in Mississippi, but decide you don't want to pay it, you can't just move to Louisiana and be free from that obligation. Louisiana courts will have to go in and enforce that against you. The contract clause. Now it's called the contract clause, but it actually had a lot more to do with other issues as well, especially with a state's ability to negotiate with a foreign power. Or to set up, titles and nobility. But the contract clause, the part that is related to contract, is that they cannot have an ex post facto law or a law impairing the obligation of contracts. In practical purposes, an ex post facto law, when you hear ex post facto, means that the law was passed after the act occurred. So if you signed a contract that was legal in 2017, and in 2015, 2022, they decide to change the law, your old contract is still in effect unless the law goes, and deliberately sets up an alternative for that contract. And it's very rare that they can do that. Usually, no ex post facto laws. And that makes sense because you don't want to enter into a contract and then you be obliged and then find out the other person isn't obliged because that state changed the law. Now we'll get to the Bill of Rights, the amendments. Now, originally they weren't part of the Constitution, but in order to get the states to pass the Constitution, to put it into effect, they added these amendments. And in many ways, what they did was they limited the power of the federal government. Just the federal government, though. States weren't bound by this until later when we have the full faith and credit. So the First Amendment protects freedom of religion, press, speech, and the right to peaceably assemble. And that ensures the citizens have the right to ask the government to redress grievances. Now we take this all pretty much for granted now as basic human rights. The Second Amendment finds that in light of the need for a well-regulated militia for security, government cannot infringe on citizens' rights to bear arms. This has been debated for decades, if not centuries, because it's poorly written. It was like, what did they mean by the first part, where they say in light of the need for a well-regulated militia, security, government cannot infringe, then the second part cannot infringe on citizens' rights to bear arms. So people focus on one side or the other side of this sentence. Originally, there was no federal army. And so they did not want a standing federal army, which we definitely do have now. But at the time, they feared a federal standing army. So they wanted the states to have people ready to fight in case of an invasion. So that was sort of what it seems they were trying to do at the time. But it doesn't say anything more than beyond these words. So it's hard to say whether they intended it to be that people could have whatever arms they wanted, or whether they had to be part of a state-run militia. The Third Amendment provides the government cannot house soldiers in private residence during peacetime or during war, except for provisions in the law. This really had to do with something that happened during colonial times and around the Revolution, where British soldiers were put into people's homes and were not only just housed there, they were informing on the people that they were living with. The Fourth Amendment protects citizens from unreasonable search and seizure, and that the government only issues warrants if there's probable cause. And probable cause is a standard whereby there is the substantial likelihood that incriminating evidence will be found when the search is conducted. So they can't randomly say, we're going to go search this person's house and see what we find. There has to be some evidence that they will find something incriminating in that person's house, or the warrant should not be issued, or the warrant becomes invalid. So, they can't just bust into anybody's house and start looking for drugs. They have to have some sort of idea that there are drugs present on the premises. The Fifth Amendment ensures the government does not put citizens on trial unless there's been an indictment by a grand jury. It gives the citizens the right not to testify against themselves. So that's the Miranda warning that you hear police always do on TV shows. Prevents the government from trying citizens twice for the same crime in the same tribunal. That's double jeopardy. The court finds you not guilty, they can't come and retry that. They could try you for something else, but if they find you not guilty, they can't come back and try you again. Creates the right to due process and provides that government cannot take private property for public use without just compensation. What they consider just compensation, sometimes that's what's debatable. You know, you might have a business that you think is great, and the government wants to take it to build an airport. How much do they pay you for building that airport? The Sixth Amendment, right? The right to a speedy public trial with an impartial jury, provides the right to know what criminal accusations a citizen faces, and provides the right to have witnesses both and for the accused, provides the right to an attorney. That's all pretty self-explanatory. The Seventh Amendment states that in common lawsuits where the monetary value exceeds $20, citizens have the right to a jury trial. Pretty low figure there, especially when you consider the cost of a jury. It was, I guess $20 was worth a lot more than that. Provides the government will not excessive bail or excessive fines, prohibits cruel and unusual punishment. And this last part that prohibits cruel and unusual punishment, that's debated a lot with the death penalty. Is it cruel and unusual, or is it not? The others is just really, you know, that the punishment needs to fit the crime. So bails will not be excessive for small matters. And it prohibits the government from imposition of excessive fines. If what you did was not too bad, the fine should not be too high. Now, the Ninth Amendment is one that I think should be used more often. But it states basically that the Bill of Rights names certain rights. You know, just because the Bill of Rights lists something, it doesn't mean to be exhaustive. There can be other rights retained by citizens. Not really brought up much by conservative, but liberals, this is kind of where the privacy rights come in, because privacy is not listed as one of the rights. But for those who believe in a more expansive list, they look into the Ninth Amendment. Probably could do more. The 10th Amendment provides that powers that the U.S. Constitution does not give to the federal governments are reserved to the states. So when you hear about states' rights, this should be legislated by the states, not by the federal government. That's where they're getting this, the 10th Amendment. Now, those were some clarifications with some of them. Speech not protected by the First Amendment. Defamation. You can't talk trash about people, their lives. Obscenity. That's highly debated. Fighting words. Threats are not protected by the First Amendment. Obscenity is kind of a moving target. The test that the Supreme Court has come up with is, would the average person applying contemporary community standards find that the speech appeals to the prurient interest? And does the speech describe sexual conduct in a patently offensive way? Does the speech lack literary, artistic, political, or scientific value? As one Supreme Court judge once said, I can't define pornography, but I know it when I see it. this is something debated more and more, is protecting the citizens' freedom of religion. Now, what the Establishment Clause actually states in the Constitution is shall make no law respecting an establishment of religion. And that states the government cannot make a law prohibiting the free exercise of religion. So, is giving money to a religious school respecting an establishment of a religion? That's debated a lot. And states that the governments cannot make a law prohibiting the free exercise of religion. So if there's a law saying you cannot discriminate against gays and lesbians, but someone says that's against their religion, which holds sway? I mean, there's some tests that the courts use. One of them is there a secular legislative purpose to the law? You know, it might have a religious impact, but is there a legislative purpose? Are they deliberately trying to help religion, or is there a secular legislative purpose? Does the statute principle or primary effect either advance or inhibit religion? So does the non-discrimination law prevent someone from practicing their religion? You know, does it? And does the statute foster an excessive government entanglement with religion? You know, there are a lot of schools that are religious that do receive money from in some way or another, but can the state then imply restrictions on how that money is used or how that religion operates? Fifth Amendment Due Process Clause states the government cannot deprive a person of life, liberty, or property without due process of law. It means they can't just come in and take it. There has to go to the courts. The court has to decide. They can't just do it with legislative action. Procedural due process requires the government to use fair procedures when taking life, liberty, or property. So, trial by jury, right to appeal, etc. Substantive due process ensures basic fairness of laws that may deprive life, liberty, or property. The Fifth Amendment's taking clause. When the government takes your property, they've got to pay for it, and it has to pay the owner just compensation or fair market value for his property. So it might not be what the business believes is the value, it's the fair market value. And there can be a lot of debate about that. Now, the 14th Amendment, now this is huge. Up until, when the Constitution and the Bill of Rights were passed, they only applied to the federal government, which means that a state could pass laws that the federal government couldn't in relations to personal liberty, speech, religion. And that's how we ended up with some states where you could own slaves. So after the Civil War, they passed the 14th Amendment, and it said that everyone who lives in a state cannot be denied the equal protection of the laws to any citizen. And that basically all people who live in a state should be treated the same by the state. In this way, it combats discrimination since it applies whenever government treats certain individuals differently than other similarly situated individuals. This is actually, well, the wording is pretty clear. It's becoming more and more debated by certain political groups, who say that this should only apply to race, because that's what they were thinking when they passed it. Others are saying, if you look at the clear words, it says anybody. So women shouldn't be treated differently. People of sexual minorities should not be treated differently by the law. So it's kind of the original intent versus the plain meaning debate. You hear that a lot when Supreme Court justices are being interviewed by Congress as to which one of these they adhere to. And the way that the Supreme Court and not all the federal courts look at it is that there's certain levels. Strict scrutiny applies to suspect classifications based on race, national origin, and or citizenship that would prevent individuals from exercising a fundamental right. Because that's what it was intended when they wrote that amendment. That's only allowed if necessary to promote a compelling state interest. So it's a very high standard that the state has to approve. Intermediate scrutiny means maybe this wasn't what they meant when they wrote it, but we consider it now. And it applies to classifications based on gender or the legitimacy of children. And so then it must be an important government objective as opposed to a compelling state interest. Proving a compelling state interest is things like order, law and order, safety of individuals. No, important government objective is a little bit looser. Then if it doesn't fall into those, there is gender, legitimacy of children, then it gets the rational basis. It applies to all other matters such as classification allowed only if it advances a legitimate government interest. But there still has to be a government interest. This is sort of where same-sex marriage comes into play, because it's not one of the strict scrutiny of race, national origin, or citizenship. It's not gender or the legitimacy of children, really. So they applied, so in the latest court case, they applied the rational basis. What is the legitimate government interest in preventing same-sex marriage? And they found there was no legitimate government interest balanced against the rights of the individual. That could change. Supreme Court, in a ruling that they made recently, said that one of the Supreme Court justices, Clarence Thomas, said that should be looked at again. Okay, huge topic we just covered. Please read the book, and just know there's a lot more to it. But we only have a little time in this class to cover this, so this is what you get. Thank you. Enjoy your week. Be good to each other, and enjoy your studies.